Now I'd like to welcome Robbie Lawson, a partner based out of our Raleigh office with our finance and real estate section. He focuses his practice on all aspects and types of commercial real estate, including buyer and seller representation in real estate transactions, commercial lease negotiation, drafting, evictions and collections, borrower and lender representation in commercial loans, solar energy and renewable energy, condominium law, easements, condemnation negotiations, land development, and commercial foreclosures. Robbie, take it away.
Thank you so much, Lauren, for the introduction. Can everyone see me? Hear me? Yes, awesome, great. Well, as Lauren said, my name is Robbie Lawson. I'm a partner in our commercial real estate and finance section in the Raleigh office. And today I will be talking about commercial leasing and specifically negotiating leases more from the tenant side than from the landlord side. So if you're with a company that is looking to lease a space or looking for to renew your existing lease, this will be very beneficial to you. If you're on the other side and someone that's in the leasing business on the landlord side, this presentation will also be useful for you to see what tenants are typically looking for in their lease negotiations. So throughout the presentation, I will be talking about 10 different tips that I recommend that tenants focus on when negotiating their leases. I'll go through these 10 tips here at the beginning and then go into more detail throughout the presentation with each one. Item 1, I suggest hiring a commercial real estate agent or commercial real estate broker to help you negotiate your lease. Number 2, prior to entering into a new lease agreement, I recommend talking to your lender, or if you're a franchisee, talking to your franchisor before entering into that lease agreement. Tip number 3, consult an attorney. Here, plug for Williams Mullen. Consult Robbie Lawson. Happy to help any of you guys with your lease negotiations. Tip number 4, discuss term. How long do you want the lease to be? Are you looking for any options to renew beyond the term? Any types of termination options? Those types of things. Tip number 5, protect yourself against early lease termination, whether that's by default or some sort of recorded document that can help you with that. Next slide. Tip number 6, safeguard your location, whether that's through exclusivity or restrictive uses or otherwise. Tip number 7, understanding as is. What does as is mean? We'll learn that when we get to that section. Tip number 8, ask for notice and cure provisions in the event of a tenant default. Tip number 9, know your rights when the landlord defaults and what tenant remedies you may have. And finally, tip number 10, we'll be discussing negotiating your personal or corporate guarantee. Now we're going to do a twist because before we even start the presentation, we're going to do our first polling question. And for my polling questions, they're more examples than questions. It's kind of a scenario, which I'll read to you now. I'm looking for a new building to lease. I don't want to hire a tenant rep broker because I think they are too expensive. My business partner told me that typically the landlord pays the landlord rep broker, who in turn pays my tenant rep broker, meaning I wouldn't have to pay my tenant rep broker any funds relating to signing the new lease. Is my business partner correct? Option 1, yes. In North Carolina, typically the tenant rep broker is paid by the landlord rep broker through a commission split agreement, with the landlord rep broker being paid by the landlord. Or option 2, no, my business partner's wrong. I better get my checkbook out to pay my tenant rep broker some money. I think you have 1 minute to review this and Let's see if we can pick the best option. I'll give you guys about 30 more seconds. Lock in your answers. About 15 more seconds. Do tenants typically pay for their broker? All right, let's see here. So go to the chat. And it looks like 77% of people said yes. Typically in NC, the tenant rep broker is paid by the landlord rep broker, meaning that the tenant does not have to pay its real estate broker. And that's correct. Now let's talk about this here. Let's talk about hiring a broker. So tip number one, why would I hire a real estate broker? Well, one, they can help me with the business terms. If I'm coming in and not really sure I know what I want, they can help me with those business terms. They're going to have knowledge of the market, and they'll help negotiate a letter of intent. Other than consulting an attorney, hiring a knowledgeable commercial real estate broker is probably the most important thing that you can do from the start. They'll help you with certain things of the business terms. Like I said, the term, whether or not you want to have an option to renew, what the rental rate should be, whether or not you should put down a security deposit or a guarantee, whether or not you should try to negotiate free rent or an allowance in the event that the tenant is actually putting some money and upfitting the premises themselves. So all those business type term things that you may not know and that an attorney may not know, the real estate broker is going to have a lot of knowledge in the area and is definitely worth your while to hire. If you don't have a broker that you know of, ask around, ask your attorney. They may have some assistance and be able to make that connection for you to make that introduction to the broker. And the real estate broker throughout the term might be able to help you with certain things. So if you are doing that upfit, they'll be able to manage and help with that upfit and construction process throughout. So tip number one, if you're going to do anything, do this from the start, hire a commercial real estate broker. Next slide. Tip number two, talk to your lender. And if you're a franchisee, talk to your franchisor before you even start doing the lease negotiations. There may be certain financial terms or requirements that your lender or your franchisor might have that you need to know about in advance, and some things that may need to be negotiated into the lease. In addition, there may be some separate documents that your lender or your franchisor may require you and or your landlord to sign as part of the lease negotiation process. Two of those documents being the landlord waiver and the collateral assignment. I'll talk about both of those items now. What is a landlord waiver? Well, a landlord waiver is a document where the lender requires the landlord to subordinate any rights the landlord may have in the tenant's collateral, whether that's your inventory, equipment, or other personal property. So it's a document between the lender, the landlord's lender, and the tenant the tenant's lender and the landlord that needs to be signed. So in these instances, in the event the tenant defaults under the lease, the landlord, per this landlord waiver, would be required to give the tenant's lender notice that, hey, the tenant is in default of the lease. And then the lender would have the right to come into the premises and remove that collateral. Or alternatively, if the tenant is in default of its loan, then the lender can notify the landlord, hey, the tenant is in default of the loan. I'm coming in there and grabbing that collateral from the premises. Same with a franchisor. So if a franchisee tenant is in default of its franchise agreement, then the franchisor can come in and grab the stuff, even though that the tenant is in default. And alternatively, if the landlord is in default of the lease, then the landlord would give the franchisor notice, hey, tenant's in default, and allow the franchisor to come in there and take the collateral from the premises. So that's why it's important negotiating that up front, because if you have signed the lease and then ask the landlord to sign a landlord waiver, it may be difficult for the landlord. You lost some of your negotiation power there, right? So I always recommend up front, hey, if there's a lender or if there's a franchisor involved, if there's going to be a landlord waiver, let's go ahead and get that signed and negotiated simultaneously with the lease. Even if it isn't negotiated simultaneously, when I represent landlords and a tenant has said, hey, Robbie, the tenant wants the landlord to sign this landlord waiver, and the landlord says, well, this is just taking rights away from me. I typically tell my landlords, yeah, but it's going to make you have a stronger tenant, because a tenant that can borrow money is going to be a stronger tenant at the end of the day. A collateral assignment, that's a little bit different than a landlord waiver. What that is that's a document between the tenant's lender and the landlord that allows the tenant's lender to come in and step into the shoes of the tenant in the event of default and basically assume the lease. Same with the franchisor. Collateral assignment for a franchisor is a document between the franchisor of the tenant and the landlord, which allows the franchisor to come into the shoes of the tenant and act as tenant under the lease. Also, these things are coupled with notice. So again, if I am a tenant and I'm in default of my lease, landlord would give franchisor notice. Franchisor could come in and step into the shoes of the tenant. Or alternatively, if I'm in default of my franchise agreement, franchisor could come in and take control of the lease that way. And same with the lender. It's similar on both sides. So, again, it's very important to try to negotiate these things up front versus once the lease is signed. From a practicality standpoint and a customary standpoint, what is customary here? Well, typically landlord waivers, I see most landlords agreeing to those all the time. As far as collateral assignments, I get a lot of pushback from landlords on those. So if that is something that your lender is going to be requiring or something your franchisor is going to be requiring, one, it may be a little unreasonable, but two, if it's going to be a requirement, that's definitely something you want to talk about up front with your landlord as soon as you can, and definitely prior to signing the lease agreement itself. With that, we'll go on to the next slide. Consulting an attorney. One more plug for Williams Mullen and Robbie Lawson on this one. So if you are negotiating a lease as a tenant, please pick up the phone or email and call a Williams Mullen attorney. What's the point of an attorney reviewing a lease? Well, one, we can look at the legal terms, protect the tenant and the negotiation of the lease, of course. Two, making sure the key points of the letter of intent are actually made it into the lease. We talked about brokers earlier and their importance. And one of the reasons a broker is so important is they help negotiate the letter of intent. And I'll tell you, if you are in that letter of intent negotiation stage, I always recommend forwarding that to the attorney as well, even though those are just the business terms for the attorney to look at before signing the letter of intent. And the reason for that is, even though most letters of intent are non-binding, it's a lot easier to negotiate the terms up front than changing the agreed upon terms and the letter of intent once you get to the lease. So having the attorney spend an extra few minutes on the letter of intent sometimes pays off in the long run. Let me tell you a story about a client that I had who said, Robbie, I'm just not sure if it makes sense. It's a relatively short lease, and does it make sense for me to pay the legal fees for you to review the lease? And I said, well, let's talk about it. How long is your lease? 5 years. If I was buying the building, then I would definitely, reach out to you, Robbie. But for this 5-year lease, I'm not sure if I actually need your help on that. Well, if you're buying a building and you're going to be hiring a real estate attorney to review the purchase and sale agreement, that purchase and sale agreement typically lasts for 60, 90 days. We're talking about the negotiation and then your due diligence period, and then you close on the building and you own the building. There may be some survivals of reps and warranties for a brief period of time, but basically once you close on the building, that document is done and gone, checked off. A lease, on the other hand, even a 5-year lease, that's going to be around for a long time, 5 years at a minimum. If we're talking about options to renew, maybe even longer than that. So I always say, the lease, unlike a purchase and sale agreement, is for a much longer period of time. And even though you're only, quote, leasing the building and it's not your building, there may be a lot more important and long-term effects in there if you don't have an attorney review it. So I always recommend, of course, consult an attorney on negotiating your lease and possibly the letter of intent if you're able to do that. I'm going to try my hardest, or any attorney is going to try their hardest to negotiate what they can for the tenant. Another thing that the attorney brings to the table is at least letting the tenant know the risk in the event that the landlord doesn't agree to what you're trying to negotiate. You at least know that on the front end and say, well, here are the risks about moving forward. And at the end of the day, the tenant can make a business decision whether or not they want to move forward with the lease or not move forward with the lease. And with that, we'll go to the next slide. Tip number 4, discussing term. So, we talked about this in the letter of intent, whether or not you want to have a short-term lease or a long-term lease. Think about your business plan and how long you want to be in the space. So I'll tell you this, it is much better to have a relatively short-term lease with options to renew than it is to have a long-term lease without those options to renew. It gives the tenant more flexibility in good times or in bad times. So if you have a 3-year lease with 3 2-year options to renew, meaning 10 years total, I guess that's 9 years, or a 9-year lease, it's better and it gives the tenant more opportunity to change up their business plan. Whether that business plan is a failure and they need to get out of the lease, that stops the liability at 3 years, or whether that business plan is a success. And after 3 years, you outgrow your space and you need more space. With the options to renew over the long-term, 10-year lease, it gives the tenant a lot more flexibility there. And with options to renew, one of the things you want to think about is the notice, the amount of time you need to give before the option to renew begins. So that the lease is ending, it's 30 days till the lease ends, and you want to exercise your option to renew, or maybe the lease ends on the day and the tenant wants to exercise its option to renew. That would be the best case scenario for the tenant. Landlords, of course, don't like that. They want to have some ability to plan. So at the end of the lease, if you don't renew, they're already looking for a new tenant. So typically I see anywhere between 12 months before the end of the term and 6 months before the end of the term that the tenant is exercising its option to renew. And if you snooze, you lose. If the tenant doesn't exercise during that time frame, then that option to renew is null and void. So anywhere between that 1 year to 6 months before the end of the lease term. So timing is important. And the second thing we want to talk about is rental rates during the option to renew. So there's two ways that I typically see rental rates for options to renew. One would be a fixed rate, an annual bump. Maybe at the end of the term, each year after that, you'll see a 3% increase annually, and that's set forth in the lease itself. Or you could see at the end of the term, for the renewal term, there'd be a fair market value rate, right? That is determined at that time. And what's important when we're talking about the fair market value rate is if you don't have the fixed, bumps, then you need a way to determine the fair market value rate in the event the landlord and the tenant cannot come to an agreement on what that is. Probably 10 or 20% of the leases that I see grant the tenant an option to renew with a rate which will be the fair market value rate, to be determined, and the landlord at its sole discretion. And if the tenant doesn't agree, too bad, and the renewal term is null and void. Well, that's not a real renewal option. So in the event that happens and the parties have agreed to a renewal option, right? That's not an enforceable renewal option. So in the event that happens, I normally reach out to the landlord and say, hey, do you have some language that you want to use to determine the fair market value in the event the parties can't agree? And I normally go that route first versus suggesting language, but the concept is there. Here is an example of a response. Okay, so in the event the parties cannot agree to the renewal rate, the landlord will hire an appraiser and get an appraisal, and the tenant will hire an appraiser and get an appraisal. And those two appraisers will try to determine the fair market value. And if the landlord and tenant and appraisers cannot determine the fair market value for the rent for the renewal term, then those appraisers will hire a third appraiser to pick from one of the two values, right? And in that way, you have a set way that the fair market value rental rate for the renewal term can be determined in the event that happens. Now, I've been practicing over 20 years, and I'm not called on the phone every time the parties can't agree, but I've only seen that happen twice. And I think the reason for that is the expense that's associated with that. And that expense is normally split between the landlord and the tenant. So most of the time, I think when we get to the end of the renewal term and the parties can't agree, they may go back and forth and either just decide to go their separate ways, or they come to an agreement that maybe neither party thinks is fair, but both parties would rather do that than go through the actual appraisal process. But what's nice about the appraisal process is at least gives both parties the opportunity in the event, and specifically the tenant, the opportunity in the event the parties can't agree. Let's talk about early termination options. So this is something that sometimes is negotiated into a lease, not always and not awful. We'll go back. There we go, early termination option. So sometimes this is negotiated in a lease, sometimes, but not often. But what this allows is a tenant that thinks that the space that they're getting ready to rent might be too big or too small for them 3-5 years down the road. So it is a pre-negotiated early termination option where the tenant has the option to tell the landlord, hey, I'm exiting this lease early. Sometimes that will be coupled with a termination payment. Sometimes that might be coupled with some sort of measurement metric. So the sales have to be this large or sales have to be this small in order for me to exercise the termination option. And then at that point, landlord will pay the tenant will pay to landlord some sort of termination option fee, or maybe some sort of reimbursement for tenant allowances, brokerage fees, those types of things. So the tenant makes the landlord whole at the end of the day. And I'll tell you, if you think that's the case, Negotiating an early termination option at the beginning is much easier than 3 years down the road calling me and saying, hey, Robbie, I want to get out of my lease. What are my rights? What are my options here? And the answer to that most of the time is nothing. I mean, you've signed a contract. If you want to get out of your lease and the landlord doesn't want you out, it's breach of contract and they can sue you. But what I normally tell clients in that situation is, hey, if you want to get out of your lease early, let's reach out to the landlord. Let's reach out to the property management company and tell them, hey, we want to get out of our lease early. And the reason for that is you never know what's going on with the landlord. The landlord may be wanting to sell the building, and a vacant building for whatever reason might be more attractive than your lease. There may be another tenant in the building that wants to expand, right? So having that conversation with the landlord versus moving out is a much better option. Or you could possibly talk about trying to assign the lease or sublet the premises. So there's a lot of different options you can do if you want out early, if you don't have that early termination option. But you know, the saying, you win more bees with honey than you do with vinegar. The best way if you want out of your lease is the honey option, and talking to your landlord and seeing if you can work out something that might be somewhat mutually beneficial versus, you know, turning off the lights and walking out and waiting for that lawsuit. All right, next slide now. All right, we're going to polling question number 2. You are in the second year of your 10-year lease. You have not recorded a memorandum of your lease with the county register of deeds. Your landlord sold your building to a new buyer. So a new landlord now owns the building. The new buyer, your new landlord, is demanding that you vacate the premises, even though they knew about your 10-year lease. So this was not a surprise. They knew you were there. And has sent you a notice terminating your lease. Do you have any rights to stay in your premises? Option 1, I'm giving you 3 options here. Option 1, yes, even if the new buyer landlord didn't know about my lease. Option 2, yes, I have some rights to stay in the premises, but only because the new buyer knew about my lease. Or option 3, no, I have no rights. I better start packing. So I will give you about 1 minute, and then I'll give you guys the results. About 30 more seconds. I haven't seen the results yet. Wait about 5 more seconds and I'll tell you the answer. Oh, here we go. Here are the results. 47% say yes, but only because the new buyer knew about my lease. And you ready for the scary answer? The answer in North Carolina is no. I better start packing. We'll get into that now. This is really scary, guys. Let's go to the next slide. Protect yourself from early lease termination. I'm going to read you a statute. It's going to be really boring. Read you a statute, and then I'm going to come back and explain it. So this statute is 4718 of the North Carolina General Statutes, entitled Conveyances, Contracts to Convey, Options, and Leases of Land. This applies in North Carolina only, by the way. No lease of land for more than 3 years is valid to pass any property interest as against lien creditors, or in this case, purchasers, for a valuable consideration from the lessor, but from the time of its registration in the county where the land lies, or if the land is located in more than one county, and in each county where the land lies, unless otherwise stated on the registered instrument on a separate registered instrument duly executed by the party whose priority interest is adversely affected. Instruments registered in the office of the registers of deed have priority based on the order of registrations as determined by the time of registration. Ugh, that's a mouthful. What does that mean? That means if you haven't recorded a memorandum of lease with the Register of Deeds office, with your landlord signing off, and then that landlord then signs a deed to a new buyer, and that buyer's deed has priority over your lease, so long as your lease is longer than 3 years, and does not have to recognize your lease. That is really scary. And let me say that again. If you have a lease that's longer than 3 years and you don't have a memorandum of lease recorded, right? And your landlord sells the building to a new buyer, that new buyer does not have to recognize your lease and can kick you out, lock the doors, evict you. Now, how often does that happen? Not very often. Why? Because typically a real estate investor buys a building for the revenue stream, for the rent coming in. So I would say 9 out of 10 times, or probably even a bigger percentage than that, you really don't have anything to worry about. However, let's say you are paying significant under market rent. Let's say a new buyer was buying a building for the sole purpose of occupying the entire building, and you're just a lowly tenant, right? One tenant in the building. In those instances, a buyer can come in, not honor your lease, and take over the building. So that's real scary. And I'll tell you, I was in a situation where I represented a buyer, and there were 2 tenants in the building. And the buyer client said, Robbie, now you told me that we could just come in there and take over the two lease spots, right? Answer to that is yes, because the NC General Statutes 4718, the leases are longer than 3 years, and there wasn't a memorandum of lease recorded. But a lot of times, a buyer may not want to just come in there, guns blazing, right, and evict tenants. Why? One, just goodwill. You don't want to get a bad reputation, those types of things, potential for lawsuits. So in that instance, my suggestion would be, if you're a landlord coming in there and saying, hey, under 4718, we can kick you out, but we want to be, good. We're going to give you a period of time to move out, those types of things to help avoid lawsuits. But in the end of the day, the landlord is going to win. So if you're a tenant in that situation, we can try to figure out some solutions, but for the most part, you better start packing. So that brings us to tip number 5, protecting yourself from early lease termination. Well, the first thing you always want to do if you're a tenant is request a memorandum of lease. What is it? It's normally a 1 or 2 page document that states the name of the tenant, the name of the landlord, the term of the lease, and the property. And that's it. You record that with the Register of Deeds. You have now protected yourself against a subsequent purchaser, a new landlord, kicking you out during the term of your lease, even though you're paying rent when due and all of that. And I'd say 50, 60% of the landlords that I work with will agree to sign a memorandum of lease, no problem. The larger you are as a tenant, the more negotiation power you have. But there are plenty of landlords who refuse to sign a memorandum of lease. It's just their protocol, their standard. Why would they do that? One, it may be a cloud on title. It's just an extra pain. When you move out, you got to get it terminated, those types of things. So when I represent tenants, I basically say, hey, if you don't get the memorandum of lease signed, this is your risk, right? New buyer can kick you out. But the likelihood of that risk is super small. But you at least know that that's there. And I don't think I've ever represented a tenant that said, I'm moving on, I'm going to rent somewhere else. But at least the tenant knows the risk there. And it is a very, scary risk. Same thing with subordination, non-disturbance, and a torment agreement, SNDA. That is an agreement between the landlord's lender and the tenant, that in the event the landlord defaults on its loan, right? So the lender is now going to foreclose. If a memorandum of lease hasn't been signed already and recorded before the deed of trust, that lender can foreclose and wipe out the lease. Again, very scary. So the larger the tenant, the more probability that you can get an SNDA signed. And the important part for a tenant is the non-disturbance part, right? So in the event that the landlord defaults in its loan and the lender forecloses, they agree not to disturb, non-disturbance, the existing tenant, and they can remain in their space. The subordination part is that existing tenant subordinates its lease to the deed of trust, to the loan documents. And the attornment part is that the existing tenant will attorn or recognize the landlord's lender as the new landlord under the lease. These things are pretty important. Always try to negotiate these things simultaneously with the lease negotiation, especially the SNDA. If you're a large tenant and the landlord is giving you a large allowance, let's say you're doing the upfit, and before you start the lease on the lease commencement date, landlord's going to give you $500,000, $500,000, and you don't have an SNDA signed and the lender forecloses, you can say goodbye to the $500,000, most likely, right? If you negotiate an SNDA and you negotiate in there that, hey, in the event that the landlord defaults under its loan, then you, lender, still need to pay me the $500,000. And you can imagine most lenders wouldn't want to do that. But that is a scenario that happens all the time. And how do we deal with that? Sometimes the landlord may put that $500,000 in escrow or with the lender or somewhere else so that it's protected, that in the event that the landlord defaults under its loan, that tenant is still protected. So these things are both important. Talk to your attorney about that. Make sure you understand the importance of these things. You may not get either of them, but at least you will know the risks. And now you do know the risks ahead of time. Next slide. Safeguarding your location. How do you safeguard your location? So whether that's by an exclusivity clause or prohibited use clause or no relocation clause, I want to talk about each of those right now. If you're an accounting firm and you want to be the only accounting firm in the building, or an ice cream shop and you want to be the only ice cream shop at the shopping center, you can ask for an exclusivity clause from the landlord saying, hey, I'm going to be the only accounting firm here in the building. I'm going to be the only ice cream shop at the shopping center. So that's one way you could do it. The second way you could do it is a prohibited use clause saying, hey, no other accounting firms other than me are allowed here in the building, or no other ice cream shops other than me are allowed at the shopping center. Prohibited use clauses can expand beyond exclusivity. And so, for example, the immoral uses, right? So it may be any immoral uses are prohibited in the shopping center. Or if you're a tenant who requires a lot of parking, you may want to have a prohibited use for a gym, right? Or something like that, that takes up a lot of parking. So, those are things to consider. But what good is an exclusivity clause or prohibited use clause if you don't have remedies, right? So what are some remedies that you could ask for exclusivity or prohibited use? Well, one of the things you could ask for would be a reduced rent. So if another accounting shop opens up in the building, during the time they're open and operated, I'm paying 50% rent. You might be able to ask for lease termination. In the event another ice cream shop opens in the shopping center, at any time thereafter, I can terminate my lease. And landlords will typically agree to these things with some sorts of limitations. Typically, a landlord is going to want to see a notice and cure provision So in the event there's a law firm in the building and they sublease to another accounting firm, right? Then the landlord has an opportunity to come in there and cure the landlord's default so they're not in violation of the exclusivity clause. Or if the landlord opens a coffee shop in the shopping center and the coffee shop also starts serving ice cream, and they're not allowed to under their lease, right? In that instance, the landlord has the opportunity to come in and say, hey, you're in breach of your lease, and some cure period before that rent reduction starts. And same with lease termination. Most landlords might agree to that, but the lease termination needs to occur after a certain period of time. So after a year, you either need to terminate or move on and stay and pay full rent again. You can't just have that ongoing termination option forever and ever. So those are things to consider if safeguarding your location and what you're doing is important and you don't want to have competition around you. The other item, if you are the top floor of the office building or the best corner in the shopping center, you may not want to have to relocate your business. So this is the no relocation clause. Most leases will obtain a clause that says, hey, landlord has the option to relocate you whenever they want to. And the reason why landlords like to do that is in the event, the smaller the tenant, the more likely a landlord would want to do that. So in the event you're a small tenant on a single floor and someone wants to come in and rent the entire floor, the landlord's going to want to have the option to move you up a floor where there's plenty of room, right? Or down a floor. And that makes sense. The larger the tenant, the more expensive the upfit, the longer the term, those types of things. Sometimes a tenant will have more negotiation power and can negotiate out that relocation clause. When the landlord insists on having the relocation clause, things I often ask for is wanting to have plenty of notice on the front end. So 60, 90, 120 days notice before you relocate me. Maybe we're saying, hey, you can only relocate me one time during the term of the lease. That might be something I'm asking for. I often will ask for a same floor or higher or same number of windows. That works in retail or office, so you're not moved into an interior unit with less windows or on a worse floor. But most importantly, if you're relocating me, you got to pay all my moving fees, right? And that's business cards, that's stationery, all that kind of stuff. You need to pay all my business fees, relocation fees. And often landlords, when they're doing this, because I've seen it from time to time, sometimes they'll even throw in a month's free rent that they didn't have to throw in. So if you're being asked to relocate, I would always contact the attorney and say, hey, this is for an existing lease. Hey, landlord's trying to relocate me. Can you help me? But in the lease itself, let's try to strike that off so that doesn't even happen from the get-go. Next slide. Understanding as is. What is as is? Where is? You hear that all the time, but what does that mean? Well, that means that if there's an issue in the premises, for the most part, that's the tenant's responsibility. Or if you got to fix up the premises, that's your responsibility. The landlord is leasing to you this premises as it looks right now. So when we see as is, there's a few things I normally try to do. One is try to exclude latent defects. If there's something hidden behind the wall, that isn't as is, that's landlord's responsibility. And I often recommend to the tenant to say, hey, let's hire a contractor. Let's go out there. Let's look at the roof. Let's look at the HVAC. So at least you know what you're getting into before you sign the lease. Because if those HVAC units are 20 years old, you either know that and budget that you're going to have to replace those, or we have that conversation now and maybe we work out some sort of cost splitting arrangement or something like that. In the lease itself, you'll often see a tenant responsible for HVAC, especially in the retail setting. And in that situation, I often try to cap the expense of the tenant or do some sort of cost splitting. For example, tenant is only responsible for the first $1,000 of HVAC repair or replacement during any 12-month period. Landlord will be responsible for anything over that. With that, landlords will often agree, but you got to talk about that as soon as possible. Letter of intent if you can, or at first round of the lease at the latest. As far as roof and parking lot, let's say there is a holes in the parking lot, and we'll get to that in default. I'll come to that example shortly. But roof, parking lot, let's say you sign a 20-year lease and the roof needs to be replaced in lease 1, and somehow you're responsible for that. Well, that doesn't seem as bad because you're going to get 20 years use out of that roof as if you're in lease year 20 and the roof goes bad, right? So I always try to get those expenses amortized over the useful life. So instead, in lease year 20 of paying for the entire roof, maybe you're paying for 1/20th of the entire roof for that. So those are things to think about, and things why an attorney can help you with understanding as is. Next slide. Negotiate tenant default provisions. I like to really focus on the tenant default provisions rather than focusing on the landlord remedies, because if a tenant actually defaults, they don't pay their rent when they're supposed to, the landlord should have the right to come in there and sue the tenant, lock the doors, exercise its remedies under the lease. What I think what an advantage that we can do on the front end is really protecting the tenant from accidental tenant defaults, right? Oopsie daisies. So, for example, rent is due on the 1st of the month and the tenant pays the rent on the 5th of the month. So technically the tenant is in default. Landlord could come in there, lock the doors, if it allows it under the lease, sue, etc., evict the tenant. But if we had a grace period that said rent isn't due until 5 days, rent is due 5 days after the due date, right? Then we have that grace period and the tenant isn't in default. Even better would be some sort of written notice and cure period. So rent is due on the 1st of the month, you pay on the 5th, and there's a provision that says tenant isn't in default until the landlord gives written notice and 5 days opportunity to cure after the default. So you get notice you don't pay on the 1st, you get notice on the 2nd, and then you got 5 days to cure. So that's even better. And most landlords will agree to that. I'll tell you a story. I had one represented a landlord, and they had a tenant that had a notice and cure period, 7 business days. And that tenant didn't pay rent until the landlord sent them a notice, and then they had 7 business days every month until eventually the tenant defaulted and they gave back the space. But in order to protect from a tenant from doing that, landlords will often push back and say, yeah, I'll give you notice and cure, but you only get 1 time during any 12-month period. And I think that's fair, or 2 times during any 12-month period. That prevents the scenario that I just talked about from a tenant taking advantage of the notice and cure period. As far as non-monetary defaults, let's say you need to put a lit sign up in front of your premises and you don't do that. Well, the landlords may put you in breach of the lease and say you got 30 days to cure, right? But maybe that's not enough. So I would normally try to negotiate in addition to 30 days, so long as I've started to cure, but I'm not able to cure, I won't be in default. So if I'm required to put a lighted sign on the building and I've ordered all the stuff and it's taken 45 days to finally get it up there, I'm not in default of the lease. So trying to prevent those tenant defaults on the front end, I really like to focus on that more than the actual landlord remedies. A couple more, go dark provision, meaning if the tenant fails to operate in the premises, then the landlord can put the tenant in default. You saw a lot of that during COVID. And you may find it advantageous to continue to pay rent, but not actually be in the premises. So trying to negotiate that in. And then some notice and cures for things like failure to provide insurance when due, or the SNDAs, which we talked about. or tenant estoppels, just giving you a little bit more time than an automatic default. So those are things that I try to negotiate in. Next slide. Polling question, the last one. Your landlord is in breach of your lease. The lease is silent on tenant remedies in the event of landlord's default. What remedies do you as tenant have as tenant against landlord in this scenario? One choice. You can terminate the lease with 30 days notice. You can sue the landlord for breach of lease. You can cure the landlord's default and bill the landlord for your cost. You can cure the landlord's default and offset your future rent, or all of these. And remember, the lease is silent on the tenant remedies. I'll give you guys about 45 more seconds to vote here. I think we got an answer. I'll still give you guys a few more seconds to answer, but I'll tell you the answer too. The number one response is all of the above. 52% say all of the above. But the actual answer is the only thing you can do is sue the landlord for breach of lease. We'll go to the next slide. So know your rights when the landlord defaults. So we're going to be talking about this. So when the landlord defaults, if the lease is silent, the only thing you can do is sue for breach of contracts. If you want cure rights, if you want the opportunity to bill the landlord, if you want to offset rent, lease termination, all those things, you got to specifically negotiate those things into the lease itself. So if we talk about, exclusive and restrictive uses, which we talked about before. So in an exclusive and restrictive use, if the landlord leases something else in the building to an accounting firm, right? You only have the rights that are specifically set in your negotiated remedies provision. So either that's terminating the lease after a year or paying reduced rent for a year or whatever that is. It's only what's in there. Let's say we talked about this. I was going to talk about this before, the parking lot. Let's say there's parking lot holes and it's the landlord's responsibility to repair or repave the parking lot, and they don't do it. The tenant does not have the option or the right to pave the parking lot and bill the landlord offset rent unless that provision is specifically set forth in the lease itself. So trying to negotiate these things in is hard, by the way. As you can imagine, most landlords either don't want to or are not going to agree to specific cure rights and offset rent rights. The one exception, which I see, or the biggest exception I see, is failure to pay the tenant allowance, right? So the example where the tenant is doing the upfit and the landlord has promised the tenant a $500,000 upfit allowance that is due upon the rent commencement date. So tenant is now in and they're looking for their $500,000 and the landlord either doesn't pay or more importantly, doesn't have the ability to pay. So it's not a fight on whether or not it's actually due. The landlord just can't pay it for whatever reason. Well, in that instance, I think the tenant should definitely have the ability to offset rent. But unless that is specifically agreed upon, the only thing that the tenant can do is sue for breach of contract. And the tenant actually has to continue to pay the landlord rent, even though the landlord owes the tenant rent, right? That doesn't sound right, but that's what the law is. So if you want to be able to offset rents, if you have that large allowance, you always want to try to negotiate offsetting the rent, especially for the allowance. But anything else that you can get is definitely a bonus. Lease termination is extremely rare. You really only see that in the event of an exclusive or restrictive use violation. Next slide. Last slide. Negotiating your guarantee. So this is negotiating your corporate or personal guarantee. There's two types of guarantees in North Carolina that you see. You see a guarantee of collection, which is tenant friendly, and you see a guarantee of payment, which is landlord friendly. 99% of the time, a landlord is going to be negotiating the guarantee and are going to be putting together the first draft of the guarantee. So you're almost always going to see a guarantee of payment, which allows the landlord to go after the tenant and the guarantor simultaneously, or even allows the landlord to go after the guarantor first without having to go after the tenant. A guarantee of collection is where the landlord has to go after the tenant first, and then only after they fail on all attempts to go after the tenant can they go after the guarantor. So in the rare situations where I'm representing a tenant and being asked to draft a guarantee, I'll draft a guarantee of collection. When the landlord has prepared the guarantee, it is not reasonable to ask for a guarantee of collection. That'd be nice, but it does not market customary or reasonable. Same with waiving NC General Statute 26.7. What NC General Statutes 26.7 says, it basically allows you to turn a guarantee of payment to a guarantee of collection, which is good. And if there's not an express waiver of NC General Statutes 26.7 in the guarantee itself, the tenant may have an argument that they can actually turn the guarantee of payment into a guarantee of collection. So if you are in the landlord business of leasing space, you always want to have that waiver in there. I don't think it is reasonable for an attorney to strike the waiver if it's already in there, but it's nice not to have it in there when you're representing a tenant. And not having spouses sign. In North Carolina, any joint assets, real estate, joint checking accounts, automobiles that are owned by a husband and wife, those items basically will be judgment proof if you only have one spouse sign. So if you're a tenant, especially like the mom and pops, when you have individual signing and spouses signing, if I'm a tenant, I like to say, gosh, my spouse doesn't have anything to do with the business. They're not going to sign this, right? Why do they have to sign? Well, the reason is if you don't have the spouse sign, any of those joint assets are basically untouchable. Finally, you can ask for monetary limits or early expirations. So maybe in the guarantee, you're not guaranteeing the whole lease payments. You're maybe only guaranteeing 1 year of lease payments. And finally, early expiration. In the event that the tenant doesn't default under the lease during the first 3 years, maybe the guarantee expires after that. If the tenant defaults during the first 3 years, then the guarantee would continue. And I know I had a couple questions. I think that is the end of time. If you did have any questions at all, there's my email, there's my phone number. Please feel free to reach out to me by either. Happy to answer any questions. Looks like we're coming up at the end of our time. If you have any questions that I didn't cover today, please send me an email so I can follow up with you.